I want to talk about the issue of the relationship between data protection and freedom of expression, and in particular about the sort of cases in which those two fundamental rights are clashing with one another. Ray's been talking about the relationship between individuals and online intermediaries. And of course, one of the very important features about a true online intermediary is that it's not looking to express anything about the world. What it's looking to do is to convey information that's being expressed by others to a wide public. And that's important because what it suggests is that true online intermediaries can't themselves invoke Article 10, the right to freedom of expression, as and when they are confronted with the right to be forgotten claims. Let's see further the Google Spain case itself, where notably Google was very careful not to mount as part of its defence that its Article 10 rights were an issue. And of course it didn't want to go down that line because to say that its Article 10 rights were an issue would potentially jeopardise its perceived status as just a mere online intermediary, a mere passive communicator or conveyor of information. But of course, Article 10 rights are fundamentally an issue whenever the right to be forgotten is being asserted, and they're an issue really in two ways. First of all, of course, de-indexation of links affects the rights of the website authors. If you're having your stories de-indexed, what that's doing is fundamentally inhibiting your ability to convey your stories, your information, your ideas to a wide online public, and therefore your Article 10 rights are an issue. But additionally, it's the Article 10 rights of individuals who want to receive information on the net that are an issue. If I can't in practice gain access to stories about this individual that I'm particularly interested in, and I'm a journalist, then ultimately my Article 10 rights are going to be undermined. So Article 10 impacts on two different and significant cohorts whenever you're looking at right to be forgotten cases. One of the key questions we've got to ask ourselves is really whether the court in Google Spain struck the balance correctly between these two competing rights. But before we think about that question, let's just step back and remind ourselves that there is a genuine and serious problem within the online environment in terms of how do you make privacy rights resonate within that environment. Because of course, historically, privacy rights haven't really had a purchase within the online world, and that is of course the issue that the European Court was trying to address in its judgment in the Google Spain case. And I think we really mustn't forget, and it was something that was touched on by Frank earlier today, that Google's power is enormous and its life-destructive effects are enormous. It can totally destroy the ability of an individual to get a relationship, to get a job. It can fundamentally conflict, as Frank was pointing out, with this fundamental imperative to permit rehabilitation within our society, which we place great store by. The question we've got to ask ourselves is whether the court in Google Spain really got the solution right to this particular privacy problem, particularly in view of its impact on Article 10 rights. Now, what I want to do is just dwell on two fundamental concerns about the practical impact of the judgment, and these concerns are real and are affecting cases that are unfolding today. Let's start with the way in which the court has formulated the legal test for achieving online data amnesia. The test is set out in paragraph 81 of the judgment, where the court held that, as a general rule, those are the important words, the data subject's rights override the interest of internet users. In other words, as a general rule, the data subject's rights, their privacy rights, are paramount rights within the online environment. They typically will trump the rights of internet users. Now, admittedly, the court does go on to qualify that principle by saying first that when it comes to striking the balance, every case must turn on its own particular facts, and second, that the strength of the interest in remembering the data may vary depending on the role played by the data subject in public life. That's all in paragraph 81. But that doesn't really get us away from the asymmetry that's inherent in the general rule that's set by the court, i.e. that privacy rights are generally to be treated as paramount. And of course, importantly, that general rule applies to data that is present on the net, that is true, and is lawfully present on the net. So what we are forgetting, as Frank was pointing out, is the truth. Now, there's a real question about whether that general rule is the right way to deal with the privacy problem. because the immediate concern that it raises is it creates a legal culture within which Article 10 rights are systematically being treated as second-class citizens within the online environment. Rights which generally have to bend their knee to the Article 8 right to privacy. The problem, of course, with that privacy-centred approach to the right to be forgotten is that it really forgets that Article 10, the right to freedom of expression, is itself a fundamental right, and a right that is no less important or fundamental than the Article 8 right to privacy. And we know that not least from countless judgments that have emerged from Strasbourg. And see further the European Charter of Fundamental Rights, which itself recognises that freedom of expression is a fundamental right. So already we have a problem with the judgment in terms of its explicit privileging of the Article 8 right to privacy over the Article 10 right to freedom of expression. And it's hard to see how that's going to bring in its way anything other than a highly asymmetrical approach to the enforcement of these fundamental rights in practice. This analytical asymmetry then feeds into a second area of concern, which concerns how the Article 10 voice gets heard in the right to be forgotten process. Now we know, of course, that if an individual wants to have certain data, certain links about them forgotten, what they do is they write to Google using Google's nifty little application form saying, please delete ABC links about me. So the applicant's voice, their Article 8 voice, is heard clear as a bell in the right to be forgotten process. But what about the voice of the author whose material is going to be de-indexed? How does that individual assert the right to have the data remembered? What about the voice of the service user, the member of the audience, who may want to have the freedom to receive that data? There's nothing in the judgment to explain how those voices can be heard in practice. In other words, there's nothing in the judgment which explains how Article 10 rights are to resonate and get heard within the right to be forgotten process. Now, it may be that the assumption is that, well, Google can itself defend Article 10 rights, both the rights of the author and of the audience members. But of course, if that is the assumption that underpins the court's judgment, it's highly problematic for a number of reasons. First, and of course this is a point picked up on by Frank, it's problematic because, of course, Google is a commercial, profit-driven animal. There may be all sorts of commercial reasons why Google doesn't want, in practice, to defend the Article 10 rights of the particular author or the particular audience that's interested in receiving that data. Those commercial interests include that, in practice, Google can't be sued by the author or the audience members if they decide to de-index, whereas it can be sued by the applicant, the person who's seeking to have their data forgotten, if Google refuses to de-index. So if you're thinking about commercial imperatives, which way are you going to go? And so where things get sticky, it's easy to see why Google might be inclined to cut the author and the audience adrift and de-index despite the strong Article 10 arguments in terms of retaining that data. So there's a fundamental problem with treating Google as an effective defender of Article 10 rights. Second, and again this is a practical point, it's highly problematic to assume that Google will be in a position to defend Article 10 rights of the author or the audience members. Because at present there is a real question as to whether Google is even entitled in law to notify, for example, the author that a request to be forgotten has been made. Certainly the position currently of the EU Article 29 Working Party is that there should be no notification, and I know that the UK Information Commissioner has recently taken Google to task for notifying authors about the fact that a request has been made. As according to the Information Commission, this is one of the big bones of contention between the Information Commission and Google. But of course, if Google can't notify the website authors of the fact that the requests are being made, how can they effectively gather together the evidence so that they can make a properly informed, balanced assessment of the competing rights? And that's a particular problem because, of course, in most cases, as a mere online intermediary, Google is a stranger to the data in question, a stranger to the data subject, a stranger to the circumstances in which the data was created, a stranger to the circumstances in which the right to be forgotten is being asserted. And in that sense, Google's role has to be contrasted with the position of an ordinary data controller, who typically will be very proximate to the data and the data subject. So there's the problem, if you like, of stranger danger. Now, is it simply that we are supposed to assume that Google is so powerful that it's effectively omniscient, such that it inevitably will have the correct level of insight into the Article 10 issues which touch on a particular case? I think there's got to be a concern that that's really expecting far too much, even of an organisation of the breadth and stature of Google. So where we're left is with a serious problem as to how to achieve a world in which Article 10 rights are being effectively asserted within the right to be forgotten process. And the court in Google Spain is just completely silent on that problem. So we have an asymmetry in terms of the legal test for achieving online amnesia, and that analytical asymmetry is then seriously compounded by the procedural asymmetry that I've just been talking about. And I just want to make clear, these aren't simply interesting, intellectual, academic, philosophical questions. I'm dealing with a case just this week for a number of national media organisations where these concerns are fundamentally in play. I won't talk in any more detail about the case, given that we're not applying Chatham House rules today. Now, it might be said, well, look, we can just leave Google to get the answers right, but I think that's really a naive way of approaching these sorts of cases. So where this takes us is that Article 10 seems to be getting short shrift as a result of the judgment. And of course, coming back to points that have been made earlier today, it may be said, well, look, it's not ideal, but it's the best that we can do in an imperfect world. And I was at a conference recently speaking alongside the head of the EU Data Protection Unit, who made the point that this is a proportionate response to the problem of privacy, because it doesn't lead to deletion of the data. The data is still out there as hosted by, you know, the Daily Mail website or the BBC website. It's more difficult to access. And that is a proportionate way of dealing with the privacy problem. Again, there's a question about whether that's a realistic view of the role played by Google in terms of accessing data and making it available to a wider public. So I think there's a real question about whether we are, as a result of the Google Spain judgment, storing up problems for ourselves in the future. I just wanted to also briefly make the point that the right to be forgotten is not the only area at the moment within the UK where data protection rights are clashing with Article 10 rights. Because within the UK, there's been a really interesting move recently towards individuals trying to use data protection legislation as a way of controlling the journalistic process. It's a new approach to reputation management. And certainly in the UK, what we're now seeing is individuals moving away from traditional defamation actions, so they don't know only too well, towards data protection claims being selected as the weapon of choice for attacking media organisations. Now, partly this is because new UK defamation laws have made litigating defamation claims extremely difficult. But partly it's also because data protection legislation offers claimants important and new tools for getting under the skin of media organisations. For example, through the deployment of subject access. You, media organisation, give me all the data about me that you hold, and give me your sources as well, because of course we know that's part of the subject access regime. And just to give you a flavour of how individuals are trying to use data protection rights to control the journalistic process, I just wanted to mention the recent case of Steinmetz against Global Witness. Now, this was the first case in the UK in which the substantive application of the journalistic exemption has been considered. I should confess immediately that I acted for Global Witness in the case, so altogether neutral and impartial. The background to the Steinmetz case is that Global Witness, as you may know, is a Nobel Prize nominated NGO which reports and campaigns on natural resource-related corruption and human rights abuses around the world. Along with a variety of other media organisations, in 2012 it began reporting on a major corruption controversy concerning the Simandou iron ore mine in Guinea, which is one of the largest iron ore mines in the world. The company caught up in the controversy was a company called BSG Resources Limited, BSGR. BSGR was extremely unhappy about Global Witness's reporting and were very keen to shut the story down, writing various threatening letters to Global Witness. What then happened is a number of individuals connected with the company, namely its founder, Benny Steinmetz, one of the richest men in the world, and 3 of its directors, sought to try and gain control of over the journalistic process by bringing a number of claims against Global Witness under the Data Protection Act. The claims included not least a claim that Global Witness had acted unlawfully by failing to respond to their very wide-ranging subject access requests, and claims that Global Witness was acting unlawfully by continuing to publish their data. And notably, Mr. Steinmetz's case was that he was so personally connected with the company, because his name was in the title, that any information about the company amounted to his own personal data, and he relied on an EU Article 29 Working Party opinion in support of that argument. Had the claim succeeded, they would have had the effect of completely shutting the story down, so complete censorship of this important story. Now, in the course of its defence, Global Witness argued that this was a complete misuse of the Data Protection Act because these individuals weren't interested in protecting their privacy rights. What they were interested in doing is furthering the corporate interests of the SGR. We went on to argue that in any event, we had a complete defence to the claim on an application of Section 32, the journalistic exemption. What happened is that the claims were stayed by the court so that the Information Commissioner could have his say on whether we properly invoked Section 32, and happily for us, the Commissioner concluded that the exemption had been correctly invoked. And in the course of his decision, which you can find on Global Witness's website, he alluded to the high public interest value of this particular story and the strong public interest in protecting the confidentiality and autonomy of this particular journalistic process. So this was a case where Article 10 rights triumphed over data protection rights, and perhaps given the facts, that's not very much of a surprise. But what the case does illustrate is that claimants who want to row against freedom of expression, whether in the online environment or otherwise, are increasingly looking to the Data Protection Act for inspiration. And what that means is that we are now living in a world where data protection rights and Article 10 rights are increasingly taking up arms against one another. And that makes it all the more important that the courts are approaching the balancing exercise in an appropriately balanced manner. It's perhaps also just worth pointing out that it's very clear from the version of the General Data Protection Regulation recently published by the European Council that there's still a lot of debate within Europe about how you effectively reconcile data protection rights on the one hand with Article 10 rights, and concerns being expressed by a number of member states that the regulation as currently structured may operate in a way that excessively interferes with Article 10 rights. So what that means is we're still very much at the foothills of these debates around the relationship between data protection rights and Article 10. Finally, I just wanted to finish on the point about profiling. It's obviously a really important issue about the way in which online intermediaries are gathering data about us, and it's something that concerns some of us, though perhaps not the wider public as much as it should. I just wanted to draw to your attention a recent judgment of the Court of Appeal in the case of Vidal Hall, V-I-D-A-L Hall, against Google, because this is the first case that is going to look at the legality of Google's secret tracking of our browsing activities. It was a case that was brought against Google. Google initially sought to resist the claim being brought on the basis that service would seem this should not be allowed on Google in the US. The matter ultimately went up to the Court of Appeal, where, again, I should confess, I appeared for the Information Commissioner, and Google's case before the Court of Appeal was, look, this is just anonymous data. It's gathered from individual devices, but we, Google, don't know who stand behind the devices. Therefore, there are no privacy implications of processing this data, and the data protection legislation is not engaged. Luckily for us, the Court of Appeal rejected those arguments, finding that, in fact, certainly the Data Protection Act was engaged in respect of this data, principally because what Google is doing, it may not know the name of users, but it's in an important entrepreneurial relationship with users, and it is individuating them both by the way in which it gathers information about their browsing habits and through its use of cookie technology, which allows it to send targeted adverts to users when they're online. So important developments going on that front. We're currently waiting to hear whether the Supreme Court is going to grant permission for Google to appeal in that case. And just a final plug, all of the judgments that I've been talking about, including the Delphi case that we discussed earlier, are discussed on Chambers Information Law blog, which is called Panopticon, which is, if you're interested in this area, quite a useful resource. I'll be another read.
Thank you very much.